Well, good afternoon, everybody. This is Brian Dayton with the West Virginia Chamber of Commerce. I want to thank everybody who's joining us today for this very important webinar. This is an issue that is really developing almost hour by hour related to the federal vaccine mandates. We have Mark Carter and Connie Weber joining us today, who are both going to be presenters on this important topic. And we have about 300 people registered for this webinar today. So just a few housekeeping items up front. If you have questions, we're going to encourage everybody to put their questions in either the Q&A box or the chat box. And then after Mark and Connie both speak, I will go ahead and ask those questions to them. We will get to as many as we can, but just please be aware that with the number of people who've dialed in today and just how wide this topic is, we'll get to as many as we can. We are also going to be recording this webinar, and so once that recording is uploaded to the cloud, we will go ahead and add it to our YouTube channel and share it on the Chamber's website for anybody who would like to go back and just rewatch it to make sure they cover anything. I just want to go ahead and first introduce our two speakers. Connie Weber with Littler Mendelson will be our first speaker. Connie regularly defends clients in claims related to discrimination and harassment, hiring, performance management and termination, leaves of absence, and disability accommodation, wage and hour, and more. Connie is an incredible attorney. She's a very active member of the Chamber's Human Resources Committee, and we're so glad she's able to join us and speak today. The second presenter is Mark Carter with Dinsmore Shohl. Mark is the chair of several labor practice groups, and he has a national practice focus on advising employers on all aspects of relationships with labor unions. He has served as on the Federal Service Impasse Panel under both Presidents George W. Bush and Donald Trump. And Mark is the chairman of the West Virginia Chamber's Human Resources Committee. So our first speaker today is going to be Connie Weber. So I'm going to allow Connie to share her screen. I'm going to turn my camera and microphone off. And Connie, thank you for being with us today, and please take it away.
Sure. Hold on, let me find it. Wherever it is.
Yeah, we see your screen share perfectly.
Okay, you see me. All right, good. All right, and I'm going to stop my video so I can concentrate on what I'm doing. All right, good afternoon, and thanks for joining us. And welcome to the Chamber's webinar, Understanding the OSHA ETS and CMS and the COVID-19 Mandates. We appreciate everyone tuning in to what is obviously probably one of the biggest employment issues I've seen in my 25 years of practice. And we understand that you, the employers, are struggling with this as well. I'm honored to speak with you today with Mark Carter, the chair of the West Virginia Chamber's HR Committee and an attorney at Dinsmore Shohl. For those of you that haven't had time to slog through all 490 pages of the ETS, well, we've done it for you. There's a lot to cover here, and we're going to try to do it in the 60 minutes and give you 30 minutes for questions. So let's get started. So in terms of the overall content of the presentation on the ETS, I'm going to discuss the timeline and current status of the federal mandates. Then we're going to get deep into the elements of the OSHA ETS, such as the scope, as well as practical aspects, such as things you need to consider when establishing your vaccine policy, testing policy, accommodation issues that are going to arise, and other workplace safety considerations. I'm also going to conclude my presentation by setting forth some action items that employers need to start doing now in order to follow the mandate and be in compliance in a timely manner. So just by way of background, many of you probably remember the day, September 9th, 2021, when President Biden issued the Path Out of the Pandemic, the COVID-19 Action Plan. There were 6 parts to that action plan, which are listed on this slide. And of course, part of that is the OSHA ETS, which we're going to discuss today in great detail. In addition, I want to make sure you're aware of some other initiatives that have been issued that interact in some form or another with OSHA ETS. The Center for Medicare and Medicaid Services also issued a rule which requires that employers who get money from Medicare and Medicaid must require healthcare workers to be vaccinated. This is separate from the OSHA ETS, but it works in conjunction therewith. That rule became effective on November 5th, around the same time as the OSHA ETS, and the deadline for employers to implement policies and practices compliance with the CMS is January 4th, 2022, as is the ETS. So employers and contractors of facilities that are receiving Medicare and Medicaid must be fully vaccinated by January 4th, 2022. These facilities do not need to worry so much about the OSHA ETS and instead should be focused on the CMS rule. So let's get into the ETS. On November 4th, 2021, OSHA released its long-awaited emergency temporary standard. It's captioned as a temporary rule and request comment, but you need to understand, in order for OSHA to issue an ETS, it is required that it must demonstrate there is a grave danger that impacts the covered workplaces and that it is necessary to protect an employee from that grave danger. This is the second ETS that OSHA has issued. A few months ago, it issued an ETS directed to the healthcare sector, concluding that at that point, there was a grave danger faced by healthcare workers, but not workers in other industries. So, and now, 4 months later, OSHA's done a 180, asserting that employees in all industries face a grave danger because there are unvaccinated workers at work sites. Then, as you probably heard, stakeholders from all sides, both employer and employee and individual states, have filed a variety of petitions for review in several courts of appeals. For those of you that don't know the nuances of challenges to OSHA rules, they must be filed in courts of appeals, not district courts. So we now have causes of action filed in a number of venues, including our own Fourth Circuit of Appeals, challenging the constitutionality of the ETS. The Fifth Circuit was the first to act by issuing a temporary stay on November 6th, staying the rule while it was being reviewed. Both parties were then asked to submit briefs arguing their position in an expedited fashion. Well, last Friday, November 12th, the Fifth Circuit upheld its stay at the ETS, and Mark's going to discuss that a little later in the presentation. Ultimately, OSHA is going to ask that all these circuit challenges will proceed under the multi-district litigation. And just yesterday, the Sixth Circuit was chosen at random to hear the arguments on this issue and make a final determination. And again, even today, there was additional developments with regard to the ETS, which Mark is going to address when he speaks. And so while there have been a lot of attention on the Fifth Circuit Court of Appeals and its action, it is ultimately going to be up to the Sixth Circuit to hear the challenges to that rule. So let's get into the ETS. What does it mean? What is the scope? And what are the requirements? The ETS was issued on November 5th, and it applies to employers with 100 or more employees. So over the next 2 months, there are things that these employers need to do to be compliant with the ETS. The crux of the rule is that employers either have to mandate vaccines for their employees or require weekly testing of employees. If the test result is negative for COVID-19, then the employee can proceed with in-person work. However, if an employee tests positive, there are certain removal requirements that must be met. This is supposed to cover over 85 million private sector workers. The administration's ultimate goal with this mandate is to convince employees to get vaccinated and to combat the grave danger that OSHA says exists. So in order to be compliant, employees must be vaccinated, or the employer must commence weekly testing of unvaccinated employees by January 4th, 2022. And at this point, everyone should know that in order to be considered fully vaccinated, a person must receive both doses of a 2-dose vaccine or 1 dose of the single vaccine, and 14 days must have elapsed since the last dose by January 4th. There's no mention of the boosters in this requirement. In addition, the rule requires that employers have a written COVID-19 plan addressing vaccinations that implements the aspects of this rule. I emphasize this aspect because if an OSHA compliance officer shows up at your workplace, the first thing they're going to ask for is a copy of the written plan. And it's critical that you start thinking about your plan now in order to be compliant by January 4th. This applies to all employees, full-time and part-time, and new hires. Further, any accommodations for religious or medical reasons are also built into the OSHA standard. So let's dig in a little bit more on scope, because that's one of the questions that was posed to me by several clients when the ETS first came out. Questions such as, what does the 100 or more employee requirement consist of? Does my company qualify? And those kind of things. Well, OSHA says that you need to count the number of employees, not by work site, but total company employees as of November 5th, 2021. And if that number reaches 100, then the ETS applies to you. And you continue to be covered by the ETS if you drop below the 100 down the road in the 6-month application of the ETS. If you, as an employer, do not have 100 employees as November 5th, you are not covered by the ETS. However, if you grow to 100 employees during the 6-month period of the ETS, then you become covered and must be compliant. So once you're in, you cannot come out, but once you're out, you can be brought in. It includes all workers, full-time, part-time, temporary, seasonal, and minors. However, in multi-employer work sites, you do not have to count employees of other companies working at the work site. A couple other things to think about include the fact that the ETS does not overlap other federal mandates. OSHA established a carve-out. So if you're covered by the federal contractor guidelines or the CMS guidelines, or if you're covered by the previously issued OSHA ETS addressing healthcare workers, then the November 5th ETS does not apply to you. So what about other states and those rules? And what impact does the ETS have on them? It's pretty complicated, and we don't have time to get into all of that. But as for now, OSHA is taking the following position. Basically, if there are laws out there that are less protected than the OSHA ETS, then OSHA says they are preempted. So the states that are passing laws saying employers aren't allowed to impose vaccine mandates, OSHA says those laws are preempted by the ETS. However, if there are more protective rules on the books in local states and ordinances, those employers, for example, in customer-facing roles, that they must wear masks, those laws would be preempted. So more protective rules can apply, less protective rules are preempted by the ETS. So OSHA is prohibiting laws from undercutting the policy considerations of the ETS, and at the same time allowing more protective rules to remain in effect. OSHA has attempted to provide some clarity regarding preemption, and employers should continue to track the laws and orders in your local area to see what's developing. But now we can discuss some of the basic vaccine considerations for employers. Essentially, OSHA is saying you have two options. Option one, mandate vaccinations except in 3 specific circumstances, such as when an employee cannot receive the vaccine because it is contraindicated due to a permanent medical condition or delayed because of a temporary medical condition, and for those who are legally entitled to reasonable accommodation due to a sincerely held religious belief or practice. Or option two, employers can require unvaccinated employees to undergo weekly testing and wear face coverings at work. So employers need to decide how they want to proceed. Employers must comply with all of their requirements under the ETS by December 5th, 2021. OSHA is allowing employers to be flexible depending on the makeup of its workplace. And yes, you can have different policies for different aspects of your workforce. So once you determine how you're going to proceed, then you need to put it in writing 30 days after publication of the ETS, which would be by December 5th. So how, as you can an employer confirm an employee's vaccination status? Interestingly, OSHA did spend a lot of time talking about this in the ETS, and there are several different ways that an employer can do it. One way is getting a copy of a written immunization record from a healthcare provider or pharmacy, copy of a vaccine record card, a copy of a medical record documenting the vaccination, copy of an immunization record from local health authorities, or a copy of any other official documentation verifying receipt of the vaccine. Having COVID does not exempt an employee from the required vaccination. An employer needs to create a roster of your employee's vaccination status. and understand that vaccine information, such as vaccination cards, immunization records, etc., is considered protected health information and therefore qualifies as a medical record under the regs while the ETS is in effect. So employers need to maintain this information as confidential and share it only on a need-to-know basis. If you started collecting information from your employees about vaccination status before the ETS was established, then you do not have to request recertification from those employees. But you do need to get the information from those employees who have not previously provided it. If for some reason an employee cannot certify vac status on one of the 5 listed ways, then the employee can sign a written statement certifying their vaccination status and acknowledging their understanding that they could be subject to criminal penalties for providing false information. So in addition to thinking about your written policy, employers need to determine how they're going to collect the vaccine certifications from their employees. And of course, it's not an OSHA rule unless it discusses how and when documentation should be provided upon request. So employees must be provided with documentation of vaccine status if they request it, or their test results by the end of the next business day. Unions are entitled to data regarding vaccine status of the workplace in a general sense, which cannot contain identifying information such as an employee's name. And if OSHA requests your vax policy and data concerning the vax status of your workforce, the employer must provide it within 4 hours of the request. Other information that can be requested by OSHA that's referenced in the ETS must be provided the next business day. So, I mean, we've already covered a lot of information, and I'm really only about a third of the way through. Another big question that many clients have been asking is whether OSHA has the authority to require employers to pay for time off related to the vaccine. Well, the answer is yes, it does. We've seen it in on-the-job injuries, benzene exposure, asbestos exposure, and now with COVID. So the issues related to paying time off and other issues related to the vaccine is not really a completely novel idea. OSHA ultimately wants to encourage employees to get the vaccine and not prevent them from doing so because they're afraid to take time off work to get it. So there's a provision of this ETS addressing paid time off. An employer must offer up to 4 hours of paid time at the regular rate to receive a primary dose of the vaccine. This does not include boosters. So if someone gets the vaccine on a weekend, they do not normally work on weekends, then you shouldn't have to pay them. But if they get it during the working hours, it is considered paid time. If more time is needed, then it is likely that it should be considered additional paid leave. So for a 2-dose vaccine, such as Pfizer and Moderna, employers will have up to 4 hours per dose of the vaccine. If someone is getting the J&J vaccine, then they need only pay a total of 4 hours for the single dose. It's important to know which vaccine your employees are getting. Employers also need to provide paid time off for recovery from side effects of the vaccine, in addition to the paid time off to get the vaccine itself. Paid time off may run concurrently with your existing sick leave policy, but if you have a separate vacation policy, you cannot deduct from the employee's vacation hours. However, you can deduct from an existing PTO policy. An employee's sick time can be used, but an employer cannot force an employee to accrue negative sick time, meaning that if an employee has exhausted their sick time, you cannot borrow against sick time that employee may incur in the future. If no sick leave is offered or has been exhausted, the employer must offer reasonable PTO for recovery. Keep in mind that just because you're offering the testing option, you may still have to pay for the recovery time if someone is, for example, not fully vaccinated by January 4th, and receives a discovery dose after that date. So what are your testing policy considerations? There's been lots of questions about this issue as well. Employers must mandate testing for unvaccinated workers. It's a mandate. This includes testing for employees who are exempt from the vaccine requirement for a qualifying medical reason or sincerely held religious belief, unless they are also exempt from testing. An employer may mandate testing for vaccinated workers. So you may decide that your policy will be to test everyone without regard to their vaccination status. That's actually acceptable under the ETS. One thing, though, employers need to keep in mind is that you need to have a testing protocol in place. How are you making sure that your employees are getting tested? When are they getting tested? How often are they getting tested? The ETS says employees must get tested once every 7 days. If an employee is not required to go into the workplace every 7 days, you can require them to be tested 72 hours before going into the workplace. So you need to determine how often your employee is going into work to perform in-person work. You may have different variables that need to be considered for employees going into the workplace daily versus those not going in daily. Maybe working on a hybrid or remote versus an in-person schedule. The ETS does not require testing or vaccinations for remote workers. They're actually exempt from the mandate. However, this means 100% remote. If you have an employee that occasionally comes into work, that's not 100% remote employee. They're not exempt from the testing and vaccine requirements. If you have a runner who makes deliveries to and from the workplace, this person is not considered a remote worker under the ETS. If you have an employee that goes to trade shows or other events as your representative, but does not necessarily come into the office, that person is not considered 100% remote. So you need to be very thoughtful in determining who is a remote worker. There are 3 other exceptions from the testing requirement. Employees that work 100% outdoors, and that means they don't come inside even for bathroom or meal breaks. Employees that do not have any contact with anyone else, for example, private entrance to a private office. Admittedly, that's very limited. And finally, employees who have been infected with COVID within the past 90 days do not need to be tested in those 90 days. This is due to the high probability that they will likely test positive in that period. A big question I'm getting is whether an employer has to pay for the test. And the ETS says no employer has to pay for testing. However, need to be mindful that many states have their own law that requires employers to pay for medical examinations, which are necessary as a condition of employment. In this case, there's no federal preemption on that issue. And West Virginia is one such state. West Virginia Code 21317 prohibits an employer from requiring an employee or applicant to pay for the cost of a medical examination as a condition of employment. A COVID-19 test will qualify as a medical examination in this instance. There may also be language in a collective bargaining agreement that requires consideration and may require the employer to pay for the test. So the ETS does not control necessarily who pays for the test, despite the explicit language contained therein. So when does the employer have to pay for taking a COVID test? Under the Fair Labor Standards Act, time spent on site during working hours must be compensated. Activities outside of working hours may need to be paid if they are integral and indispensable to the principal work activity. So the question is whether testing is integral and indispensable to the principal working activity of your non-vaccinated employees. An activity is considered integral and indispensable if it is an intrinsic element of the employee's principal activities and one with which the employee cannot dispense if they are to perform their principal activities. So in states that follow the Fair Labor Standards Act and the Portal to Portal Act, which includes West Virginia, many legal scholars believe that time spent receiving a vaccination under an employer-required vaccination program outside of normal work hours and not on the employer's premises will likely not be compensable time for the average office or manufacturing worker. However, it's best that you confirm this approach with your wage and hour counsel in making a final decision on the issue. Next question would be, who pays for the expenses incurred in getting the test? expenses such as mileage to go get the test, things like that. Well, the ETS does not require employers to pay for these expenses, but again, it doesn't preempt state law that may require reimbursement for such expenses. So again, check with your wage and hour practitioner. So what about home tests? Some of my clients have actually considered purchasing a large bulk of the at-home PCR COVID-19 tests to distribute among their employees to test before they come into work. But under the ETS, this is not an acceptable testing protocol because the employer is required to monitor the testing to make sure it is conducted properly and the results reported accurately. So you may need to have a designated proctor in your workplace watching the employees swab their nose, insert the test strip, and review the results in order to be compliant under the ETS. Telehealth proctoring is also an option. This is where someone in a remote online situation can watch the employee self-administer the test to make sure it's done accurately and then view the results. Or you can send the employee to a pharmacy or health department to be tested. However, if you choose to have tests administered in-house, you need to keep in mind other health and safety protocols related to bloodborne pathogens, proper safety equipment, et cetera, that need to be followed. So to summarize the testing requirements under the ETS, testing of unvaccinated employees to report to the workplace is mandatory. It must be done once every 7 days, and the employee must test negative to remain in the workplace. If an employee tests positive for COVID-19, they must be removed from the workplace immediately, and you should conduct contact tracing to see if anyone else was exposed. The ETS provides some considerations, but not all of them. And so what are the other safety considerations that you need to give some time to? Employers still need to do contact tracing, masking, and possibly social distancing in certain situations, even though the ETS is silent on these subjects. So employers should do really a job hazard assessment and build your policy based on those job hazards. And you still need to hold on to those masks. Unvaccinated employees must wear a face covering at work or in a vehicle with another person. And again, continue to follow CDC guidelines to lessen and avoid exposure at work. There are notification requirements under the ETS that are the employer's responsibility. You need to put together a memo, an email, something in writing to employees that include the following information. Information about the requirements of the ETS, as well as the workplace policies and procedures established to implement it. Information about protections against retaliation and discrimination. Information about laws that provide for criminal penalties for knowingly supplying false statements and documentation. Also, provide employees with the CDC document, key things to know about COVID-19 vaccines. It's very informative and an excellent resource. Communicate ahead of time where employees can go to get vaccines near the workplace or how to find locations near their homes and keep this information easily accessible. Detail whether employees must seek testing outside of work hours. So what if an employer decides, I don't want to do it. I don't want to follow the ETS. And believe me, I've had discussions with some clients to this degree. It's not a good idea. OSHA emphasizes egregious violations and ignorance is not bliss when it comes to OSHA. So if an employer, for example, is not maintaining a vaccine roster or not mandating face coverings for unvaccinated employees, you could be slapped with an egregious violation for failure to comply. However, at this time, we don't even know if the penalty is going to be assessed per person or per instance. That has yet to be determined. What I can tell you is it will likely be expensive. Violations of the ETS, other than willful violations, at least at this time, are priced at $13,000 a piece. So let's talk about accommodation and what your requirements are under the ETS. The ETS identifies 3 circumstances under which an employee may be entitled to an exemption. First is when the vaccine is medically contraindicated, meaning it's not recommended that this employee receive the vaccine because of a health condition. Another is when the medical necessity requires a delay in the vaccination, or because of a qualifying disability or sincerely held religious belief, practice, or observance conflicts with the vaccine requirement. Disability is defined very broadly under Title VII and our own West Virginia Human Rights Act as well. It's a physical or mental impairment that substantially limits one or more major life activities, including major bodily functions. Employees with a disability are entitled to an accommodation if it is necessary for them to perform the functions of their job, and an employer can provide the accommodation without undue hardship. With respect to religion under federal law, we're looking at a 3-pronged test. Is the belief religious, not personal? Is the belief sincerely held? And would providing the accommodation impose an undue hardship on the employer? Mark's going to discuss the recent law that was passed by our West Virginia legislature addressing these types of accommodation. So stay tuned for that in his presentation. If you are accommodating someone who cannot be vaccinated due to a qualifying disability or sincerely held religious belief, they still need to wear masks in the workplace and must be tested. It is clear that in accommodation situations, the cost of testing must be incurred by the employer. Some employers ask if they can just put someone on an unpaid leave rather than accommodating them in the workplace. And the EEOC makes this very clear that unpaid leave should be considered a last resort. So really you need to explore other avenues and options before you would consider putting someone on unpaid leave because of their vaccination status. So look at all the accommodation requests very closely. The last thing you want to do is deny a request that leads to a charge that then in fact leads to a systematic case. If an employee happens to file a claim alleging failure to accommodate, the Equal Employment Opportunity Commission investigation will most likely not be limited to the specific instance at hand. Instead, the EEOC is likely to demand to see all the records of every employee that requested an accommodation and was denied in a certain time frame, for example, 2 years, as is applicable under the statute. It's not a happy place to be. So what about state laws that require additional accommodation? The ETS basically states that the only basis for which an employee may be granted an exemption are those recognized under federal civil rights law. And Osha takes the position that conflicting state laws that provide alternate grounds for exemption are preempted by the ETS itself and the federal standard. Right now, as we know, the ETS is subject to numerous legal challenges, and whether the federal standard preempts the state law is going to turn on the outcome of the cases now pending before our Sixth Circuit. An employer must engage in the interactive process to evaluate a request for accommodation. There's no one-size-fits-all approach in the workplace. Every single specific fact specific to that employee and their work environment needs to be considered. A full dialogue and solid documentation is truly your best defense. I would absolutely encourage everyone to review the EEOC guidance on accommodations. It's been updated and it's very robust and a really good resource on this issue. So what do you need to do today to be compliant with the ETS by December 5th? Well, I put together a little spreadsheet for you. Here's a task list and the deadlines for the same. These deadlines may relax a little due to the litigation involving the ETS, but it really doesn't mean these things shouldn't be done now. It's like I kind of equated to when we were in school and we were anticipating a snow day the next day. So you didn't do your homework and you're thinking that school was going to be canceled, and you woke up the next day and there was no snow and you had school and you hadn't done your homework. You know, heed my words, don't expect a snow day. OSHA has also provided actually some model policies for employees to use with regard to vaccination and testing that you probably should take a look at and see if you can use them at least as a framing point for your own vaccination and testing policies. They give you an idea as to what at least OSHA thinks is most important. So what do we do now? I say stay tuned. We're going to hear a lot more about the ETS in the coming weeks. The chamber may be doing some more webinars. I know my firm has several planned on wage and hour issues related to the ETS, vaccine policies and testing and accommodations, just to identify a few. So with that, I'll pass the mic to Mark, and I will stop sharing my screen. All right, Mark, I should have stopped sharing my screen. It's all you.
Thank you very much, Connie, and I appreciate everybody's participation as well. As Brian mentioned, this has been a pretty challenging topic to try to assist you in understanding, primarily because the standards surrounding the emergency temporary standard have changed frequently, as recently as this morning. So this iteration of my PowerPoint literally was composed for the last time at about 1 o'clock this afternoon, because it is that fluid. It also has been a topic that has captured the attention of the employer community throughout the nation, of the U.S. Chamber, as well as our state chamber. And it is a focus of a lot of work and a lot of attention. So let's try to get into the topics that I want to cover this afternoon. One, what is the status of the ETS? What is it, the authorization of the agency to implement and enforce the emergency temporary standard? What does our state law say about the topic that is the subject of the emergency temporary standard? And finally, what does the National Labor Relations Board say about an employer's obligation where the employer's employees are represented by a labor organization? What are our duties as the employer community with regard to collective bargaining as set by the NLRB? And again, a lot of this has been very recently changed. So let's talk about the circuit court orders. Circuit courts of appeal have jurisdiction to review administrative regulations. And upon the issuance of the ETS, there were many lawsuits, petitions for review filed in the various circuit courts because it was a ETS from OSHA. Employers and states could go directly to a circuit court of appeals and were not required to go to district courts first. So the state of Texas led a contingent of organizations, including employers, in a lawsuit filed in the Fifth Circuit Court of Appeals, literally upon the issuance of the ETS. And on November 6th, the Fifth Circuit prohibited enforcement of the ETS. By its terms, that order was pretty narrow. It only addressed the emergency motion filed by the petitioners in that case. And it was not clear at that time if the order was national in scope, if it was limited only to the states within the Fifth Circuit, or it could have only applied to the petitioners in that case. So on November 12th, the Fifth Circuit issued another order after briefing from both the US government and the petitioners. And in that far more detailed 22-page opinion, the Fifth Circuit extended its stay on OSHA that prohibited OSHA from taking steps to implement or to enforce the ETS by an order on that Friday night. The opinion was certainly scathing. The opinion was comprehensive and highly critical of OSHA and the United States government as a whole in issuing the ETS. The court found that OSHA and the current administration had created the mandate in a workaround, through a back door, effectively, to issue an almost certainly illegal and unconstitutional administrative regulation. The court appeared to expand its scope, or at a minimum, to clarify its scope as being far broader than initially understood. And it is very clear now that the court issued its order with nationally in scope by citing the language that it is further ordered that OSHA take no steps to implement the mandate until further court order. The Fifth Circuit decision was the opinion of one circuit court, but when petitions are filed in a majority of the federal circuit courts of this nature, the United States court system can, utilizing a process involving multi-district litigation, select one circuit court of appeals that will have jurisdiction over all of the similarly framed petitions. And so the multi-district panel of the United States courts can conduct what is literally a ping pong ball lottery, where they utilize a ping pong ball that identifies various circuit courts in order to select at random one circuit court to resolve all of the litigation and that has jurisdiction over all of the litigation. Yesterday, that circuit court was selected by a ping pong ball, and it is, as Connie said, the Sixth Circuit Court of Appeals in Cincinnati. Many legal analysts had suggested that because the Fifth Circuit was extremely conservative, composed of a majority of Republican appointees with a 1/3 population appointed by President Trump, that was a bad example with regard to what we could expect in terms of treatment. In fact, labor unions filed in 3 traditionally left-leaning circuit courts of appeal, including the Ninth Circuit, in an effort to create the opportunity for one of those circuit courts to resolve the litigation. Well, the Sixth Circuit is expected to appoint a panel of 3 judges, which is typical, to establish a scheduling order and then to resolve the case. That initial panel of 3 judges will issue an initial opinion. The court may expand the number of judges to be en banc or include all of the judges on the Sixth Circuit to treat that decision. And then if the US Supreme Court wants to, it can exercise jurisdiction to review that decision. But we should all acknowledge that the order of the Fifth Circuit Court of Appeals remains in effect. Any party can move to lift that stay or to modify that stay, but until that happens, that Fifth Circuit order remains in effect, although it would be enforced by the Sixth Circuit. So in terms of the politics of the Sixth Circuit, there are 5 active judges on the Sixth Circuit who are appointed by Presidents Clinton and Obama, and 11 judges appointed by Presidents Bush and Trump. In total, there are 20 active and senior status judges in the Sixth Circuit who are appointed by Republican presidents and 6 appointed by Democratic presidents. About 1/3 of the court's judges were appointed by President Trump. In reality, this is effectively the same metric that is in play in the Fifth Circuit. They are almost identical in terms of the composition of the courts with regard to political affiliation. So most recently, if you look at the COVID-19 vaccination and testing ETS webpage of OSHA, on an hourly basis, you would have found last night that this is where the agency chose to make us aware that it was taking steps. It was not taking steps, it was suspending its activities related to the implementation and enforcement of the ETS pending legal developments in the litigation. That's how we got notice at some point last night that the agency was suspending its activities to implement and enforce the ETS as a result of that Fifth Circuit order. How long will the activities be suspended? We don't know. What legal development would change the government's position on this? We don't know. However, what we do know is that the activities of implementation and enforcement are temporarily suspended. This is the snow day. It's just we don't know how many days we're going to get off school because of the storm. And many legal analysts are opining that there is a strong likelihood that the agency will not be able to enforce its timelines. Are they right? Are they wrong? We simply don't know at this juncture. But this is one reason why, as an employer, you should stay tuned, as you were counseled to, because we will get further clarification and definition on that. The activities to implement and enforce are stayed. OSHA did not expressly state this, but as I said, most legal analysts believe that the December 5 and January 4th dates are likely to be enlarged. And OSHA has confirmed that it intends to vigorously litigate the matter up to and including the US Supreme Court. Ultimately, that is likely where the decision is going to be made. And obviously, all of the enforcement deadlines are contingent upon the ETS surviving both constitutional and statutory review. As Brian has mentioned and Connie has mentioned, our legislature did in fact create a state law that touches upon the subject matter that is the source of the ETS. And the United States Department of Labor has emphasized that the federal regulation will preempt any state law that is contrary to or impedes the enforcement of the federal regulation. And the ETS itself announces its primacy over state law. The US Department of Labor also has authority to put any state agency in effective receivership that does not mandate the same terms of the ETS. However, we are not the same as many states in that we don't have a baby OSHA or a little OSHA. And while we do have a state agency that enforces mine safety health, MSHA is not a part of the ETS, although mining employers who have more than 100 employees likely will be subject to the OSHA regulation if it is enforced. So what does our state law do? State has created a law with conflicting terms with the ETS. On October 22, the governor signed into law SB 335, which creates West Virginia Code 16-3-4B. This law permits employers in West Virginia to require employees to be vaccinated against COVID-19. However, the law does contain two significant exemptions. There's a health exemption, which states that the employer, where an employee presents to the employer a certification signed by a doctor or an advanced practice registered nurse who has personally examined the employee and states that a COVID vaccination is contraindicated or the employee has COVID antibodies from being exposed to or suffering from COVID, then that's a satisfactory medical exemption. As Connie explained, that wouldn't pass muster under the federal standard because simply because you have the COVID antibodies does not necessarily mean that you are somehow exempt medically from the vaccination or testing requirements. The other exemption is the religious exemption that states that an employee who presents a notarized document announcing that the employee has religious beliefs that prevent them from being vaccinated is enough. There is no requirement for a sincerely held religious belief. There's no requirement for an interactive process where the employer and the employee discuss the situation to determine whether or not the exemption requested by the employee creates an undue burden on the employer. And as such, that distinction would not pass muster again under the federal ETS. Those are significant conflicts between the state law and the federal emergency temporary standard. The state law then prohibits employers from discriminating against in any way employees who exercise exemption rights with this language. A covered employer shall not be permitted to penalize or discriminate against current or prospective employees for exercising exemption rights, including but not limited to hiring, firing, or withholding bonuses, pay raises, or promotions. So essentially anything. The employer is prohibited from discriminating against or penalizing an employee who has exercised their exemption rights under the state law. The state law and the federal ETS present several areas of potential conflict. As regards employees who have exercised exemption rights, does the employer discriminate against exempted employees by providing paid time off to employees who avail themselves of the vaccine, as they are required to do under the ETS? The exempted employees don't get that paid time off. Does the employer discriminate against exempt employees by providing sick leave to employees who experience side effects from the vaccine? Again, the exempt employees don't get that paid sick leave. Does the employer discriminate against exempted employees by requiring them to purchase and wear a mask and pay for and undergo weekly COVID testing? Well, this is kind of a trick question because, as Connie explained, we have a state law that requires employers to pay for the testing, despite the fact the ETS expressly permits that. But if you have operations in another state, for example, where that requirement or that state law requirement is not present, then this could come into play. Does the employer discriminate against exempt employees by submitting their affidavits of religious exemption to OSHA? We know that OSHA can pursue criminal penalties for anyone knowingly supplying false statements or documentation. So an employee who claims they have a sincerely held religious belief and presents an affidavit confirming that to the employer when that doesn't really exist, is that discriminatory by submitting that affidavit to OSHA and allowing OSHA to further investigate that? These are legitimate questions, the most legitimate of which is which law prevails? Well, the ETS represents that it supersedes any inconsistent state law or local ordinance, and that is correct. The Supremacy Clause of the United States confirms this. In any statute, state law statute, government or county ordinance, which is frustrating or an impediment to the enforcement of the federal law or regulation, is unconstitutional under the Supremacy Clause. But the ETS may currently be stayed nationally. In fact, it is. And we know that the agency itself has confirmed that it is suspending its activities to implement or enforce the law. Does that change things? Well, the state law likely conflicts with the ETS, but it would ordinarily be effective where it is not in conflict with the federal law. So simply because the federal law may be stayed or suspended doesn't mean that the state law will be. And the state law is set to go into effect in early 2022. And as far as we know, it is on track to become effective at that time. Now, The state law also could be inconsistent with Title VII of the United States Code because it removes the interactive process and the undue burden protections that employers enjoy under that statute regarding an employee's entitlement to religious exemptions. So if an employer is sued under the state law because of alleged violations, that defense could be raised. Finally, if a state law is unconstitutional, there's no severability language in our state law, and it could be unconstitutional in its entirety. Typically, a state law will state that it is, if any portion of it is determined to be unenforceable under law or a constitution, then that portion of the law will no longer be enforceable, but the rest of the law will. It's called a severability clause. Because this statute does not contain a severability clause, and I would underline that our legislature considered that, but chose not to include a severability clause in the law. And there's ultimately a determination that any part of the law is unconstitutional. That would indicate a likelihood that the entire law would be considered unconstitutional. So what are your obligations? Well, if you have less than 100 employees and there's no federal law in effect, or there's no federal law in effect, then you are expected to follow the state law. If you have 100 or more employees and the federal law is in effect, federal regulation, whatever it happens to be at that point, you should follow the federal regulation. One thing is certain, I think all of us would encourage you to make sure that you have consulted with a competent lawyer who understands what the law is at the time you speak with them to assist you in determining what course of action you should follow. Again, this is changing by the day, by the hour. And now there's another relevant federal law that we should consider. The General Counsel's Office of the NLRB issued guidance on November the 10th, detailing that employers may not unilaterally implement vaccination and testing policies to comply with the ETS if they have a collective bargaining relationship with a labor organization. Rather, where an employer has discretion to implement various terms and conditions to comply, it must provide notice and an opportunity to bargain with the union representing its employees to negotiate over those terms. So the most likely term nationally that employers and unions are going to talk about is the weekly testing for COVID and who is going to be responsible for those costs, as well as masks. But when I say masks, one of the leading cases on this issue historically is a case where an employer could comply with a federal regulation issued by Osha regarding the use of respirators, which is a mask. And the employer had the opportunity to comply with the regulation by using one of 4 different types of masks. Because the employer could require the use of any one of those 4 different masks, the employer was required to negotiate with the union when it requested negotiations over which of those masks the employees would be required to use. And that's how intricate and specific it can become. Today, the ETS does not provide an employer with a safe harbor for delays on meeting implementation deadlines due to continuing collective bargaining. So if you sat down with your union tomorrow and they wanted to go to the mat over what type of mask you were going to require your employees to use who are unvaccinated, you may be in a tough spot with regard to meeting the December 5th and 6th, frankly, the 6th for having a policy ready, and January 4th even for having the testing regimen in place. Because you were collectively bargaining. And while one would presume that you couldn't be fined because you were satisfying your duty to negotiate under a federal law, the National Labor Relations Act, that's not expressed. I asked the General Counsel if the employers in the country could anticipate guidance on this issue and the potential of a safe harbor during a meeting of the U.S. Chamber on November 9th. The General Counsel did issue the guidance, make it public on November the 10th. She acknowledged that it had been used internally for some period of time at the NLRB, and they did make it available to the public as a result of that question on November 10th, but there has been no identification either by the Department of Labor or the NLRB as to whether any type of safe harbor will exist for those employers who are continuing to negotiate. The status of the ETS, as I've said 5 times, is evolving daily, if not hourly. To prepare for its enforcement, we would counsel you to continue to prepare for its enforcement until a court with competent jurisdiction says you do not have to. Now, when I prepared this, I didn't anticipate that the Occupational Safety and Health Administration would throw up its hands and say, no, we're not going to enforce our own regulation. They have done that, but they haven't told us how long that will last. So ignoring this emergency temporary standard, I think, is a very risky business. Our continuing recommendation will be that employers should prepare for it, anticipating it will ultimately be enforced until a court with competent jurisdiction says it won't happen. That's a real possibility. Anybody who's read the Fifth Circuit opinion released Friday night of last week knows that, but it's not a certainty. And seek competent counsel to assist you as that continues. I appreciate your attention. I know that several of you have posited questions, and I'm confident that, well, I know that Connie and I will do our best to try to respond to those.
Well, thank you, Mark. Just to go ahead and remind everybody, if you have questions, you can go ahead and type them into the Q&A box. I believe Connie has actually answered several of those questions actually in that box. So those of you who have asked them, double check that. One of the questions we've gotten several times is, will the slides be available? And I've reached out to both Connie and Mark privately. The answer is yes. So the way that we will handle those is I'm going to ask everybody to email me directly, and I put my email into the email or into the chat box. It is bdayton@wvchamber.com. So you can email me directly. Just be mindful, please give me a little bit of time to go ahead and respond to those. I think Mark and Connie are going to go ahead and convert those over to PDFs. And then I will go ahead and hopefully by tomorrow, I will get back to you with those slides. I do see a new question we have that just popped in. It's from Jim Kaufman, president of the West Virginia Hospital Association, great friend of the chamber. Jim has asked, if an employee refuses to be vaccinated, what happens? Do they qualify for unemployment? And, you know, I would just add in, are there differences there between the CMS and the Osha rules related to that?
Well, under the ETS, if they refuse to be vaccinated, then they must be tested. And they must test negative to get to be allowed entry into the workplace. Do they qualify for unemployment? That's going to be an interesting question. That's what we're going to see some developments with Workforce West Virginia with regard to. I mean, obviously, it's going to be a termination, right? You're not following protocol or policies and procedures, so you're being terminated. But it's going to be an interesting take to see what the deputies and the ALJs take on that. What do you think, Mark?
Well, I hope that can you guys hear me? I just wanted to make sure my computer's acting weird, but I think that Connie is onto it. Any employee who refuses to comply with the federal regulation is going to have a difficult time convincing an ALJ that they were not engaged in misconduct. There are 2 levels of misconduct under unemployment comp law. One of them would prohibit you from getting any type of compensation. The other would limit the amount of compensation you will get. So I think it's likely that employees who refuse to comply with the regulation would be determined to have engaged in misconduct, The issue is going to be then whether or not that misconduct is the more severe or the less severe. And then let's not forget the state law. The state law prohibits employers from discriminating against an employee who exercised an exemption. So if that employee sought to exercise an exemption in compliance with state law, and the employer challenged their entitlement to unemployment compensation, I think the employer would be doing that at their own risk.
Thank you, Mark. We have two more questions in that are very similar, so I'm going to combine them. The first question is, we have seen through an industry publication that companies holding a federal contract will be required to have 100% of their employees vaccinated. Is that a part of this OSHA ETS, or is that a separate mandate? And then a supplemental question to that would be, what is the definition of contractors versus vendors?
Connie, you want to do that? You want me to do that?
Go for it.
All right, it's separate. There are three different regulatory actions that are in play with regard to vaccinations and testing requirements. The question that the attendee asked deals with the federal contractors regulatory action. It is not a part of the OSHA ETS, although if the federal contractor has more than 100 employees, then the federal contractor could be obligated under both pieces of regulatory action. What's the difference between an independent contractor and a vendor? Well, an independent contractor or a federal contractor is generally the employer, the party that has a contract with the United States government to provide goods and or services that meet a relatively complicated definition of who a federal contractor is. It is not necessarily or simply a vendor. The other thing that I wanted to mention, I thought I saw a reference to this question, is what about the other regulatory action? The other regulatory action, and Connie did describe it, is the CMS, which deals with healthcare providers who have contracts for receipt of Medicare and or Medicaid reimbursement for services and products. Now, the CMS regulatory action is also being challenged legally. But as far as I'm aware, there's only one legal action challenging that regulatory action. That's in the state of Missouri, or federal court in the Eastern District of Missouri, near St. Louis. And it is a lawsuit called State of Missouri et al. Versus Joseph Biden et al. And it is a lawsuit based primarily upon the Administrative Procedures Act under the United States Code. So there is not the same volume of legal action challenging the CMS regulatory action as there is the ETS. And they're all three separate pieces of regulatory or administrative action, although the OSHA ETS has uniform application, whereas both federal contractors and the CMS regulatory actions are far more defined and limited in scope.
Thank you. At this point, do not see any open questions. Mark, Connie, this has been an absolutely fantastic and very informative webinar. Really appreciate both of you for taking the time to research this. I think, Connie, did you say it was 492? Is that correct? Pages to dive through.
490 pages, 490 pages, densely encoded.
Yes, a lot of stuff that and it takes, that is not easy reading. That's very difficult reading to go through that much. So really appreciate both of you for doing this. As a reminder to everybody, this webinar will be available. What we will do is once it uploads to the cloud, we will go ahead and make sure that we share that with the Chamber's website, and just watch for this week's news update from the Chamber, because we will make sure that link to this webinar is posted there so that you can go back and watch this. And again, anybody who wants to have a copy of the slides, just send me an email, bdayton@wvchamber.com. Please give me a day to respond. So if I don't respond to you right away, don't be offended. But what I'll do is once I have those slides from Mark and Connie in a PDF format, I'll start working through the emails that people have sent and send those slides over to you. So again, thank you both so much for doing this. This has been an incredible service to the members of the West Virginia Chamber, and we really appreciate everything you do to help move West Virginia forward.
Thank you, Brian. Thanks, everyone.
Thank you.
All right, thank you.